Taiwo. All right, so we have with us in the studio, we have a legal practitioner, Chief Robinson Ario. He's with us here in the studio. Good morning, sir.
Very good morning to you and good morning, Deltons.
Yes, so nice to have you with us this morning in our studio, sir.
Always a pleasure.
Yes, sir. Sir, let's get illegal. What is at play here, really? What's the issue? What is the bone of contention, really, here?
Well, it is important to point out that both parties fully understand the issue. And the issue is about the inconsistency in the name structure and combination of the PDP candidate.
Name structure and combination.
For example, I am Robinson Orishemuminawo Ario. Okay? Now, if I add Matthew to my name in some documents and remove Orishemuminawo in some other documents, so you see that the structure, that is my name, my first name, surname, and other names, if they are not consistent in the documents that I submit, including the form itself. Now, when you are talking about certificates, the Supreme Court has said that certificate is not just your qualification from school. It is the declaration, the depositions that you make in the relevant forms to INEC, because you say, I declare, I certify that this information and that information is true. And one thing that the Supreme Court frowns at is the use of names whimsically and capriciously. What I mean by that is that you use this combination for this purpose, you use that combination for another purpose, you use other combination for other purposes. You can see now that what PDP is trying to do, what Obrower is trying to do, is to explain the inconsistencies in his name. Okay? Is to explain the inconsistencies in the combination of his name. In some documents, you have XYZ. In some other documents, you have XBYZ, just like that. And he said he has told us that he has even published the correction, the explanation in a gazette. So basically, all the issues at play here were the issues that were at play in the Bayesta case, which we popularly know as PDP against Degi Eremioyo, you know. So in that case, the following were the issues. One, how does a person change his or her name or correct his or her name if those names are absent, if need arises? And the Supreme Court has said in that case that, one, it is not just by affidavit. You need to do what in law is called a deed pool. And after doing that...
So what okay, just go on.
After doing that, you need to possibly make it available by way of gazetting it, which Orori is saying that he has done. Okay? So the issues arise from the fact that there are inconsistencies in the structure and combination of his name, surname, and other names. In some documents, you have this. In other documents, you have that. And so he has also said he came out to explain it. Now, it is important that I read out something to you in this this Bayesa case, which we all know.
Okay.
It's the issue that arose to be determined in that case was whether fraudulent for one person to bear different names. That was ratio 3. Whether fraudulent for one person to bear different names. So the Supreme Court had it to say, it is clearly fraudulent for a person to allegedly bear several names that he uses variously to suit changing environments. Okay? Now, it goes on to say that at page 132 is the statutory declaration of age deposed to by one Henry Vanham, an uncle of the first respondent. It was claimed therein that the name of the first respondent as at 31st July 1999 was Biobarakuma Degi. However, in the purported affidavit of regularization, the name deposed to by the first respondent on the 18th September 2018 before a faceless notary public, the first respondent averred that my name at birth is Biobarakuma Wanagaga. So what the Supreme Court was obviously frowning at here is the inconsistency. Here, even though one name may run through all the instances.
Because I was about asking that same question too, because from what we've seen,
Yes.
Oborowori is common
Yes.
to all the names.
Yes.
So
But even
is that not the same person? Is it a crime to have multiple names?
no, look at what the Supreme Court said here. I quote, "It is clearly fraudulent." That's not my word. Perhaps I'm being misled by the holding of the Supreme Court here. He said, "It is clearly fraudulent for one person to allegedly bear several names that he chooses variously to suit changing environments." What he's saying there is that if I'm called to come and present my WAEC result, I will say that I am Robinson Ario. If I'm called to come and present my university degree, I will say I am Robinson Minogo Ario. If I'm called to come and present my national diploma, I will say I'm Robinson Matthew Ario. So even though Ario, of course, it's consistent in all those. But the Supreme Court is saying you cannot just choose to use different combination and structure of names for one environment and use another for another environment. Okay? So now you can see that the team of Oborowori understand this very well. In this case too, the Supreme Court spelled it out how we can correct or explain those inconsistency, and that is why Oborowori is the article we spoke about off set just now, that Oborowori is trying to explain. He said he had through a gazette explained ratio 2 of this Supreme Court case also spelled that out. So what everybody is dealing with now, mind you, it was based on this substantially that the Federal High Court came to its judgment. It was based on this. So the definitions of...
So the issue here we are looking at now, we're not looking at forged documents, but the inconsistency in the structure of the name, and that's the issue.
Yes, and in this case
so
too...
if I get you clearly now, the Supreme Court, and the precedent is set in that Bayelsa case, it's criminal to do that.
It's fraudulent.
It's fraudulent, rather.
Yes.
Fraudulent is the word
To do that. So, and that's why I said it is fraudulent, because what the court concluded is that you choose to use the combination of names to suit different occasions. Okay? Even though there is one running through them. And you see, I must explain this. When you say certificate, when you say forgery, what you actually forged is that form, that INEC form that you filled, because you declared in the INEC form, that you are this, and that. Okay? And when on the occasion, when those going through your forms, pick your forms, when they pick your school certificate, they see that you are OJ Simpson. When they come to your degree, they will see that you are OJ Matthew Simpson. When they come to your diploma, they will see that you are Robinson Ario Simpson. Even though Simpson runs through all of them, the Supreme Court is saying you cannot just decide to choose the combination of names that you want for this occasion and for that occasion. Now, if you do that, there's a remedy, which is the remedy that he's saying he has.
Okay, so I want you to break that remedy down. Earlier on, you talked about deed poll.
Yeah.
So how does it work? Because now it seems all of us, we are ignorant in Nigeria, both the led and the leaders, everybody. Because those days when we were in school, some of us, unknown to us, we are victims of this same thing that is happening now. Because you just go to the Federal High Court here, and all those guys that will be doing typing to change your name. They just type something for you, affidavit, pam, stamp it, and that's done. Now, and you go away. So
in this case,
how does the deed?
I just want to run through this.
Okay.
The ratio of the Supreme Court in that case, it was on procedure for change, correction, and confirmation of name. Ratio 2 in that case, it says that affidavit of change, correction, and confirmation of name has to be by deed pool and not by mere deposition. In the instant case, the trial court was right that it is only by a deed pool and not by mere deposition that a change in a name on an official certificate can be effected. And further, that since the procedure necessarily affects official record and archives of the nation, it is after the deed pool that the deponent approaches the Nigerian Civil Registry to have the change published in an official gazette. None of this procedure was done by the first respondent. So what the first respondent failed to do in that case is what Oborowori's team, from what you brought out just now. You said that you brought an article out.
Yes, there was an article on Vanguard about a few days back where he
Yes.
said, uh, I want to quote it now because it's here before me,
Yes.
where he said, I explained purported differences in my certificates with government gazette.
Good.
I want you to explain all of these things
Okay,
because
good.
these are
So,
legal terms.
Okay, see, so what we do in the court is the first step to the change of name.
What's the first step?
You do an affidavit, a deposition, but that is not just all. Now, a deed poll is a document that you ask your lawyer to prepare. It's a special
So, meaning if I want to change names
Yes,
now,
yes.
I need the services of a good
Lawyer.
and eminently qualified
Yes.
lawyer.
So there are 3 steps based on this judgment.
Please explain the steps.
The first one, the affidavit. The second one, the deed poll. The third one, the registry, which will now be published in the Gazette, which he is saying he has done there. So having done that was what was not done by the first respondent in this case. But he is now saying that he has done that because obviously they have studied this case to know what the remedies are. So the bottom line is that it is not an offense ordinarily for you to have your names inconsistent in documents. But there is a remedy for it. Those 3-step remedies you need to follow to be able to effectively do the correction.
Okay.
After doing the correction, you can't go back again. You see, and that's the problem.
So
you correct now, you publish now, tomorrow you bring up another combination of names. So once you have corrected, you have corrected.
Okay, so on what ground did Justice Taiwo arrive at that pronouncement?
Good. You see, the confusion was created by the Senate and the House of Reps. You know that we now have the 2022 Electoral Act, which is different from the former one, the old Electoral Act 2015. So the point I'm making is that you find that what Taiwo did was to follow the decisions here. Namely, that having submitted those forms are also by this authority called certificates, in the sense that you certify the form. That INEC form is something you take to the court to stamp, if you know what I mean. So you are certifying that the information you gave here are correct. So if it is found out that the information there are not correct, then you are guilty of falsity. And the Electoral Act specifies what should happen. And in going to what should happen, the Act modeled up things as per 1, if this happens, what should be the consequence, both for the candidate and for the party? You will notice that even though in the Electoral Act 2022, the definition of candidate is contained there. The Electoral Act defines candidate as a person that has been nominated by a political party. But the Act in that section goes on to say that where this happens, you disqualify the candidate and take the next highest scoring candidate, which is impracticable, because at that time,
is it just disqualify the candidates? What about the sponsoring party?
Good, that one is also there. You see, but what Taiwo did was not to go to the next arm. So what he did was to disqualify the candidate and hold that the challenger is the fit and proper person to be there. So you now have a problem.
Is that in consonance with the new electoral law, that pronouncement?
The electoral law is not elegantly drafted. It's a confusion, because if you look at it, there are 2 interpretations you can give to it. One is that some part of that section is talking about tribunal and election matters. Some part of it is talking about pre-election matters. And this particular case is pre-election.
But some lawyers have argued that section of the law that law is a hybrid law. I don't know what they mean by that.
Okay, when you say it's a hybrid law,
what do they mean?
You mean that it can both be used for pre-election and for the election matter. But let me ask you a question, a simple question. How many candidates do you have in PDP? Just one. The others are aspirants. Is it not?
Yes.
Good. So when you have one blue and 10 red, and you delete a blue, do you still have another blue that you will substitute that blue with? No. In other words, if you look at the act says that any aspirant who believes that the information given by a candidate is false may approach a federal high court to determine that. Okay? So any aspirant, because there's only one candidate, you attack the candidate, then the law is now telling you that the next scoring candidate, you can't have a candidate. Throughout the entire pre-election process, you can only have one candidate. So when you delete that candidate, there's no longer any candidate, because all other persons are aspirants. The act has told you that a person who is a candidate is a person that has been duly nominated by the party. Only one person was nominated, and that's Oborowei. The moment you delete that candidate, there's no other candidate. So how do you now interpret it? If it was hybrid, in the sense they are meaning it, it would mean that the moment you delete a candidate, you either pick the next scoring aspirant, highest scoring aspirant, or candidate, in which case aspirant for pre-election matter, candidate for the election matter. But there is only one word, and the act itself has defined who a candidate is. So is there any other person nominated by the party apart from Oborowei? No. So there's a vacuum. And that's why I say that whichever way you want to look at, and that is the problem we have in Nigeria, is that those who make laws are the potential beneficiaries of the law. So they design the law in their mind. Instead of making laws for the purpose of suiting the situation, they have some people in their mind while drafting the law. And that is why a legislator can come to a state and say that we are the one that made the law. This is the reason why we made the law. Remember that your intention, your objective, in those days in school, when you are doing your project work, you have a statement of problem. That statement of problem drives every other thing that you do. So in their mind, they were focused on certain persons. So they missed the point. So for me, the act defines who a candidate is. A candidate is a person that has duly nominated. The moment you delete that candidate, there are no candidates anymore. So you can't refer to anybody as a candidate.
So are you saying that an aspirant cannot be used to replace a candidate, considering the way the law is drafted?
Yes, it cannot, because it says that the candidate with the next highest score. So the question is there a candidate with the next highest score when you remove Oborowei? No, there are only aspirants.
Well, it means anyway. We'll continue with the discussion after this time. Stick around. Mega Palava Town Hall meeting will continue.
Bros. I say you get my mind. What you say you can say na bros. You say you brought out all the technical.
Now, Oborowei is approaching that at the time they approach the court, and that time his name has not been forwarded to INEC. That's the case of Uganda.
Yes, you are very correct.
That thing was premature.
Yes, I agree with you. There's also a decision of the Supreme Court who supports this. They just created confusion for us because they were.
I don't think they will survive it. With the explanation, I don't think they will survive it. It's not yet Uhuru.
It's not yet Uhuru. It's not yet Uhuru.
George Ogulasowe-Timinimi is a dependable team player with a flair for results.
Let's change my.
Is powered by Team George.
How do you say, bro?